Imagine walking into a courtroom, right, to report a severe crime.
Right.
You expect the focus to be on the evidence, on the accused, and, on figuring out if the event actually
Well,
happened.
go with the facts.
But instead, the person sitting on the bench looks at you, hands you a psychological diagnosis, and just dismisses your entire case because of it.
It's a terrifying thought.
It is. And today, welcome to our deep dive, because for you listening, we've got a very brief but incredibly heavy stack of notes today. It's about a psychological concept that did exactly that. We're looking at Dr. Richard Gardner and a framework he created called parental alienation syndrome, or PAS.
And before we really get going, I need to jump in here and set some ground rules for today's discussion.
Oh, absolutely, yeah.
Because the notes in front of us deal with highly charged themes. I mean, we're talking about child sexual abuse allegations, really bitter family court battles, and deeply controversial psychological theories. So we are going strictly by the book today.
Right, totally impartial.
Completely.
Mm.
Our approach is purely analytical. We aren't planting any ideological flags. We're not taking any political sides. The goal here is just to look impartially at the mechanics of what the source material states. We want to map out how this concept functioned historically and, understand the friction it caused within the legal system.
Yeah, we are basically looking at the architecture of a controversy. And here's where it gets really interesting. The notes make it clear this wasn't just some, theoretical debate confined to a medical journal.
No, not at all.
This was a concept that actively altered the reality of family courts. It fundamentally changed how justice was administered. But, okay, before we get into the fallout and the courtrooms, what actually is parental alienation syndrome?
Right. We have to define it first.
Yeah, we need to understand the mechanics of the theory itself before we can understand how it was weaponized or used at all.
Well, based on the historical context outlined in the source text, parental alienation syndrome was framed by Dr. Gardner as a dynamic occurring primarily during child custody disputes. The core assertion of his theory is that one parent, what he called the alienating parent, is essentially brainwashing or programming the child.
Like turning the kid against the other parent.
Exactly. Programming them to unjustly fear, hate, or reject the other parent. So in this framework, if a child suddenly makes severe allegations against one parent, or just point blank refuses to see them.
Which happens in these bitter divorces, right?
Right. PAS suggests this isn't necessarily because the child was actually harmed by that parent. Instead, the theory posits it's because the child has been psychologically manipulated by the other parent into fabricating the abuse or the fear.
Wow. Okay, so it's a framework that fundamentally questions the actual origin of a child's claim.
Precisely. It casts doubt right out of the gate.
Which brings us to the primary and honestly starkest assertion in our source text today. The notes explicitly state that parental alienation syndrome was frequently used in family courts, specifically to dismiss allegations of child sexual abuse.
Yes. That is the core fact we're looking at.
Let's unpack this for a second. Let's think about the mechanical shift happening there. You have a theory that says, hey, this child's claim of abuse might just be the result of brainwashing. It acts almost like a legal trump card or like an eraser.
An eraser is a really good way to put it.
Right, because if a psychological concept is being used specifically to dismiss severe allegations in court, how does that shift the entire burden of proof away from the alleged actions and onto, the psychology of the accuser?
Well, it functions as a complete redirection of the court's attention. I think about a standard evidentiary scenario.
Okay.
If a severe allegation, like child sexual abuse, is introduced, the primary mandate of the court is to investigate the accused. Did the event happen?
Is there physical evidence?
Exactly. Is there corroborating testimony? The spotlight is squarely on the alleged perpetrator and the alleged act. But when parental alienation syndrome is introduced into the proceedings, that spotlight forcefully swings 180 degrees.
Wow. So the court stops looking at the accused entirely and starts investigating the psychology of the accuser.
Precisely. The question shifts from, did you do this, to, are you, the reporting parent, fabricating this because you have a syndrome and want to alienate your ex-partner?
That's a wild inversion.
It's a total inversion of the burden of proof. The person who is trying to protect the child suddenly has to prove that their own mind isn't playing tricks on them, or that they aren't engaged in this malicious campaign of psychological manipulation.
So the actual allegation of abuse just gets swallowed whole by the psychological diagnosis?
Yes. The notes highlight this as a controversial legacy for a reason. There was massive friction between addressing legitimate abuse and applying Gardner's PAS framework.
Wait, okay, I have to push back here a little bit.
Sure, okay.
Because family court judges, they aren't psychologists, but they aren't naive either.
Yeah.
They deal with messy divorces and false claims literally all the time.
Every single day, yeah.
Right. So if someone comes in with a theory that is essentially acting as a shield against abuse allegations, wouldn't the opposing counsel just tear that apart in cross-examination?
You'd think so.
Like, how does a legal system, which is built on this adversarial process of testing evidence, just wholesale adopt a theory that actively erases claims of severe harm?
That is the exact systemic vulnerability the source text is pointing toward. To understand how it survives the adversarial process, you really have to look at the unique environment of family courts.
Okay, how are they different?
Well, unlike criminal courts, where you have juries and a very strict standard of beyond a reasonable doubt, family courts are usually presided over by a single judge.
Right, no jury.
No jury. And that judge is making a determination based on a much broader, much more subjective standard, which is the best interest of the child.
Which sounds good on paper, but it's incredibly vague.
It is incredibly vague. And these judges are frequently overwhelmed by incredibly complex he said, she said custody battles. They are desperate, truly desperate for tools that offer some kind of clarity.
So they turn to expert witnesses.
They turn to psychological evaluators. And here is where language becomes so important. When an evaluator walks into a courtroom and uses a term that has the word syndrome attached to it, it carries an immense, often completely unearned weight of clinical authority.
Oh, wow. Yeah. Syndrome sounds official.
It sounds official. The suffix syndrome implies a recognized, measurable, objective medical reality. It sounds like a hard science.
It sounds like a clean diagnostic answer to a really messy, unresolvable domestic dispute.
Exactly. The judge isn't necessarily evaluating the granular scientific validity of the theory, right? They don't have the time or the medical background. They are deferring to the clinical-sounding label provided by the expert.
It's the halo effect of medical terminology.
Right, halo effect, yes.
The court assumes that because it's called a syndrome, it must have gone through, rigorous scientific vetting by the medical community. But the notes we have today point out a massive flaw in that assumption.
Structural flaw, yeah.
Right. They tell us that if you look at the foundational blueprints of this theory, Dr. Gardner's own writings, they actively minimize child sexual abuse.
This is a huge point from the text. The underlying literature, the very DNA of the syndrome, contained a built-in minimization of the exact type of abuse the courts were supposed to be adjudicating.
Okay, let's unpack the logic of that for a second, because it's staggering.
It really is.
If the creator's own foundational texts are minimizing the abuse, then the system built on those texts will inevitably do the same thing.
That's the logical progression, yes.
It's like a judge using a map to navigate a minefield, but the guy who drew the map intentionally left the mines off the legend because he didn't think they were a big deal.
What's fascinating here is that your map analogy is spot on for how precedent and literature actually function in law.
Really?
Yeah. When we say his writings minimize child sexual abuse, we are talking about the starting premise of his theoretical framework.
Okay, define minimization in this context.
In a clinical and legal context, minimization means looking at an allegation of profound trauma and structurally treating it as something less significant, less believable, or less damaging than it objectively is.
So it's not just ignoring it, it's shrinking its importance.
Exactly. You take the gravity of the abuse
and
you dilute it at the foundational level of the theory itself.
But again, I keep getting stuck on the mechanics of the courtroom here. If Gardner's own writings were openly minimizing this abuse, it wasn't a secret, right?
It was published. It was right there in the text.
Right. So why wouldn't a lawyer just hand the judge one of Gardner's papers and say, hey, look at what this guy actually believes. We cannot use his syndrome in this court.
Well, sometimes they did try, but you have to remember how psychological frameworks become institutionalized.
Okay.
Once a concept gains traction, once it is cited in a few key legal cases or, taught in a few seminars for custody evaluators, it takes on a life of its own. It becomes entirely separate from its creator.
So it gets divorced from Gardner himself.
Yes. Evaluators start diagnosing PAS without necessarily reading Gardner's original minimizing essays.
Oh, wow.
They just learn the basic diagnostic criteria, right? Like, child hates parent A, therefore parent B must be alienating them.
So they're just checking boxes.
They're just checking boxes. The system trusts the label. And by blindly trusting the label, The legal system unwittingly imports the minimization that is embedded within it directly into the courtroom.
So the court is operating on a biased algorithm, essentially.
A bias algorithm, exactly.
It's like putting a filter over a camera lens that completely blocks out the color red and then wondering why the camera can't see the stop signs.
That's a perfect way to visualize it.
The danger is right in front of them, but the theoretical filter of PAS actively removes it from the picture.
And the text we're analyzing explicitly links the application of PAS to the dismissal of these severe allegations.
Right, it wasn't just a theory, it had a function.
Yes. It highlights this as a controversial legacy for a reason. This wasn't an accidental byproduct or, a rare misapplication of the theory. According to the historical notes we're examining, dismissing abuse claims was a frequent functional outcome of using PAS in family court.
Which creates this sort of seesaw effect in terms of credibility.
How do you mean?
Well, if the underlying literature tells the system to inherently doubt or minimize the severity of an abuse allegation, then any time an allegation is made, it actually strengthens the case for PAS.
Yes.
The allegation itself becomes the proof of the syndrome.
That is the trap. The system becomes entirely paralyzed in its ability to recognize actual harm.
It's a catch-22.
It is a complete catch-22. If reporting abuse is categorized by the framework as a primary symptom of alienation, then the more severe the allegation, the more alienating the reporting parent is deemed to be.
It's just a closed loop of logic.
A completely closed loop. It leaves literally no room for the possibility that the child is telling the truth and desperately needs protection.
And this brings us to the ultimate, unavoidable outcome of all of this. We have to move from the theoretical blueprints and the courtroom mechanics directly to the fallout.
Yes. We have to look at the impact.
Because the notes state that the application of these theories had devastating real-world consequences on families.
And I think it's important to pause here. When you are reading about clinical definitions, or, analyzing the burden of proof, it is so easy to view this purely as an academic exercise.
Or like a legal puzzle.
Right, a puzzle.
Yeah.
But the phrasing in the source material demands that we look at the human cost.
For you listening, it is easy to read about court precedents and clinical syndromes, but we need to define what devastating consequences actually looks like in the context of family law.
It's not just an emotional descriptor.
No, it's a structural outcome. We are talking about dismantled families.
Yes.
We are talking about a scenario where a parent brings forward a legitimate cry for help, trying to protect their child from sexual abuse, and the court's response is to slap them with a PAS label.
And the legal mechanism of that devastation is profound.
Let's talk about that mechanism. What actually happened?
Well, if the protective parent is diagnosed as an alienator simply because they reported abuse, the court's prescribed remedy under the PAS framework was often to remove the child from that protective parent.
Just taking a second to think about that, they removed the child.
They removed the child because the logic within the framework is you have to cure the alienation by cutting off contact with the brainwashing source.
Meaning the court takes the child away from the parent trying to protect them and places them directly into the custody of the parent accused of the severe abuse.
That was the devastating consequence.
The notes mention unprotected children. That is the most literal translation of that phrase imaginable.
It represents the ultimate failure of the family court's foundational mandate.
How so?
Well, the state's entire jurisdiction in these matters, what they call its parents' catria authority, is built entirely on the obligation to protect the vulnerable and ensure the safety of the child.
That's the whole point of the court.
That's the whole point.
Yeah.
But by adopting a theoretical framework that inherently minimized abuse and inverted the burden of proof, the court system was weaponized against the very people it was designed to protect.
It really makes you step back and look at the fragility of the institutions we rely on,
It really does.
Because we walk into a courtroom expecting a kind of mechanical precision. We think of the justice system as a scale where facts are weighed objectively.
We want to believe that, yes.
And we assume that the psychological evaluations that judges rely on are like x-rays. Like they're just neutral tools showing what's under the surface.
But this legacy demonstrates that some tools have an agenda written right into their blueprints.
Yeah.
A psychological theory is not an X-ray. It is a lens crafted by a human being. And if that human being's foundational writings minimize certain realities, the lens will inevitably blind anyone who looks through it.
And the terrifying part is how easily that lens was adopted by the system.
It was seamless.
The system sought a shortcut. Judges and evaluators wanted a neat, categorical solution to incredibly messy, complex human disputes. They grabbed onto the shiny label of a syndrome without fully vetting the architectural flaws of the theory itself.
I think the philosophical weight of the terminology used in our source material really captures the entirety of this dynamic.
You mean the words used in the notes?
Yeah, words like minimized, dismissed, and devastating.
Yeah, those are heavy words.
They are. Because to dismiss an allegation isn't just to ignore it legally, it is to render it
To
non-existent.
wipe it off the record.
Exactly. And to minimize abuse is to fundamentally deny the reality of a victim's lived experience. When an institution adopts a framework that structurally does both of those things, the resulting devastation isn't a glitch in the system.
No,
It is the system functioning exactly as the flawed blueprint dictated.
it's a cascading failure. You start with one creator, Dr. Richard Gardner, whose writings minimize child sexual abuse. You package those writings into a clinical-sounding concept, parental alienation syndrome. You introduce that concept into an overwhelmed family court system that is just looking for easy answers. You use it as a mechanism to dismiss severe allegations and completely invert the burden of proof.
And the inevitable result.
The inevitable result at the end of that assembly line is unprotected children and shattered families.
It is a staggering chain of causality, and it serves as a deeply sobering case study on the intersection of psychology and law. It highlights the immense responsibility that comes with introducing behavioral theories into an environment where they have the power to literally alter legal reality.
We've covered a lot of dense, difficult ground today. To quickly recap the journey through this stack of notes for you listening, we explored Dr. Gardner and the highly controversial legacy of parental alienation syndrome. We looked at the mechanics of how it was used in family courts to dismiss allegations of child sexual abuse, essentially erasing claims of harm. We unpacked the reality that the foundational writings of the theory actively minimize that very abuse. And we traced that flawed blueprint all the way to its tragic endpoint, the dismantling of families and the absolute failure to protect vulnerable children.
It is a critical piece of historical and legal context.
Oh,
And as we wrap up this analysis, I want to leave you with something to consider.
okay. What is it?
Well, we've just traced how a single, highly controversial psychological theory became so deeply embedded in the legal system that it inverted the burden of proof and caused devastating consequences.
Yeah.
It forces a much broader question. If a single controversial psychological theory can do that, it makes you wonder how many other unexamined psychological frameworks with equally flawed blueprints are currently acting as invisible judges in our courtrooms today.
That is a deeply unsettling thought and one that is going to stay with me for a long time. Thank you so much for joining us on this deep dive. We really appreciate you taking the time to explore the mechanics and the weight of this incredibly important topic with us. Take care and keep asking the hard questions.